I had just finished a long day of deliveries for a local courier service in Boise, Idaho, when my phone buzzed with a frantic message from my cousin Haley. She rarely texted unless something major was going on, so my heart lurched. "We have a big problem," she wrote, followed by a string of exclamation points. "Your farm is, well, you're not going to believe this. They're turning part of it into a private park." I blinked at the screen. That couldn't be right. My farm, a small but cherished piece of land I'd inherited from my grandpa, was miles outside the city, near a sleepy little town with hardly any visitors. There was no reason for anyone, let alone a powerful homeowners association, to wander out there. But Haley insisted I call her immediately, so I pulled over at the next gas station, bracing myself. She answered on the second ring, breathless. "They're calling it the Glendale Preserve," she said, "and they have signs up saying, 'Private Park, Glendale Estates, residents only.' They put up a wooden pavilion near your pond, cleared a bunch of brush, laid gravel paths through the orchard, like they own the place." My jaw dropped. Ever since Grandpa passed, I'd tried to keep the farm in decent shape, even though I lived in the city now. It was mostly an orchard with a handful of apple trees and a wide stretch of meadow leading to a small pond. I'd never had big plans for the land, but it was full of memories. My grandpa teaching me to fish in that pond, showing me how to prune an apple tree so the fruit came out sweet. I couldn't imagine letting anyone else claim it. Yet, apparently, that's exactly what was happening. I rushed home to my tiny rental apartment, grabbed my old farm keys, and loaded my dog, Rusty, into the car. I planned to head out first thing the next morning. As I tried to sleep, my mind buzzed with questions. Who exactly was Glendale Estates? And why did they think they could just build a private park on property they didn't own? Haley mentioned a woman named Diane, the HOA president, who had a reputation for being ruthless in pushing Glendale Estates' interests. The estate was a well-to-do gated community on the opposite side of town, nowhere near my farmland. It didn't make sense. Had they expanded? Did they buy land from someone else and get confused about the boundaries? Or was this a deliberate land grab? By sunrise, Rusty and I were on the rural highway leading out of Boise. The bustle of the city gave way to open fields and low hills as we reached the old county line. A few more miles down the road, I could see my grandpa's farm coming into view. And sure enough, there was a newly installed wooden gate by the main entrance. A shiny metal sign read, "Glendale Preserve. Access restricted to Glendale Estates residents." It was almost laughable in its brazenness. The farm's official deed was in my name, inherited after Grandpa passed. The gate was locked, too, forcing me to park on the shoulder. Fury bubbled up in me as I hopped out, letting Rusty sniff around while I yanked on the padlock. The chain rattled, definitely locked tight. I spotted a neatly printed pamphlet tacked to the inside of the gate. It boasted about Glendale Estates' new Green Initiative to provide residents with private natural retreat areas. My orchard was apparently one of those retreats. They'd even listed a schedule of exclusive HOA events planned at the new park, including a harvest festival and a children's nature day. My hands shook as I realized they were basically using my orchard like it was a public amenity, except public only to them, not to me. Before I could tear down the pamphlet, a sharp voice spoke up behind me. "Excuse me, you can't be here." I turned to see a security guard clad in a Glendale Estates uniform stepping out of a parked golf cart. He looked official, with a badge that said Security Patrol. His posture was stiff, like he was ready for an argument. "I'm just trying to access my property," I replied, trying to steady my anger. "I own this farm. There shouldn't be a lock on that gate." The guard frowned. "Ma'am, Glendale Estates maintains this park for our residents. Do you live in Glendale Estates?" I almost laughed. "No, I do not. But I am the landowner. This is my orchard." He blinked, clearly uncertain how to handle that revelation. He tried calling someone on his radio, but it crackled with static. "I'm sorry," he said at last. "I'm under strict orders not to let anyone in who's not on the Glendale access list. If you have a dispute, you can contact our HOA office." He pointed to a phone number on the pamphlet. That was the last straw. I yanked the pamphlet off the gate, stuffed it in my jacket pocket, and told the guard I'd be back with proof that this property was mine. He shrugged helplessly as if he didn't care either way. Fuming, I headed back to my car, Rusty following close behind. The farmland was visible just past the gate. My old apple trees, the winding path that led down to the pond, and now a new gravel walkway branching off to a wooden pavilion perched near the water. It looked like they'd even installed benches and a few stylish trash cans. The entire scene felt stolen, like I'd just stepped into an alternate universe where a wealthy HOA decided to adopt my farm as their own personal retreat. No warning, no courtesy calls, nothing. I took a deep breath, trying to calm down as I climbed back into the driver's seat. My next stop was the county recorder's office. If Glendale Estates had somehow acquired a portion of my farm, it would have to be on record. I drove into the small town center and parked by the modest brick building that housed the recorder's office, courthouse, and a few other municipal departments. Inside, a tired-looking clerk greeted me. Her name tag read Wanda. When I explained my situation, her eyebrows shot up. "They built a park on your property?" "That's a new one," she murmured, flipping through digital files on her computer. "Let's see if any ownership changes or easements were filed." 10 minutes later, Wanda looked just as perplexed as I felt. "I have the deed right here in your name, no record of any sale or partial transfer. Glendale Estates definitely doesn't own any portion of your..." She printed out copies of the official deed, the boundary maps, and a statement verifying that no new changes had been recorded. I thanked her, tucking the documents under my arm, and left feeling a little more confident. I was still confused, but at least the law seemed to be on my side. Next, I drove a mile down the road to the county sheriff's station. If Glendale Estates had forcibly taken my land, that had to be some form of trespassing or land theft. However, the deputy I spoke to seemed unsure how to proceed. "We usually handle more straightforward boundary disputes, fence line issues, that kind of thing," he admitted. "But a full-blown park built on your property without your permission? That might need a court order to enforce removal." He suggested I contact a lawyer, then potentially file for an injunction to stop Glendale Estates from continuing any further work on my farm. By this point, it was nearly lunchtime, and I decided to call Haley for a second opinion. She was livid when she heard about the locked gate and the clueless security guard. "You should talk to Charlotte. Remember Charlotte from high school? She's a lawyer now, works in property disputes over in Coeur d'Alene," Haley said. We'd lost touch after graduation, but I still remembered Charlotte as a sharp, no-nonsense type who always debated teachers in class. If she'd gone into property law, that might be exactly what I needed. After a quick online search, I found Charlotte's firm and called. She answered politely, but once I introduced myself and explained the situation, her tone switched to alarmed disbelief. "A private park on your orchard? You're joking." I assured her I wasn't. We agreed to meet the next day at her office so I could hand over the deed, maps, and whatever else I had. Leaving the sheriff's station, I decided to take one more peek at the orchard from a different angle. I drove around the back roads, approaching the farm from behind, near an old dirt path Grandpa used to use. It was overgrown with tall grass, but I navigated slowly, hoping to see if Glendale Estates had started building anything else. Through the trees, I glimpsed a second gravel pathway that definitely hadn't been there before. It snaked through what used to be a wildflower meadow. Farther on, I saw a sign that read, "Nature Trail." A couple of people, seemingly Glendale Estates residents, were strolling along, enjoying the fresh country air, as if they had every right to be there. My blood boiled at the sight. This was no minor fence line error. They'd systematically transformed a chunk of my farm into a fully developed park, complete with signage and scheduled events. That evening, I crashed at Haley's place, flipping through Grandpa's old records. He was meticulous about property lines. There were decades of documents, purchase records, boundary surveys, even hand-drawn maps. My orchard was 100% ours, no question. Grandpa had always joked that if anyone tried to take so much as an inch of his land, they'd have to pry it from his cold, dead hands. Now, ironically, that was almost what Glendale Estates was doing. But Grandpa wasn't here to fight back, so the task fell to me. Early the next morning, I said goodbye to Haley and drove north to Charlotte's office. She was waiting for me in a sleek conference room. Her eyes widened at the stack of documents I'd brought, but she seemed eager to dive in. As she perused the deed and boundary maps, her expression shifted from puzzlement to outrage. "There's no gray area here," she said, tapping the table for emphasis. "This farmland is undoubtedly yours. Glendale Estates has zero claim to it. I'd bet money they never tried to record anything with the county, or else it'd be flagged as an obvious conflict." I nodded, relieved but still confused. "So what's their angle? Why build a park on land they don't own?" Charlotte shrugged. "Maybe they thought the owner wouldn't notice, or maybe they had some handshake deal with a prior occupant. Even so, it's your land legally." We spent an hour discussing strategy. Charlotte explained we could file a cease and desist letter immediately, demanding they remove their structures, the pavilion, and anything else they'd installed. If they refused, we could escalate to a lawsuit for trespassing, property damage, and possibly more. An injunction might be necessary if Glendale Estates tried to fight it. "The real question," she mused, "is whether they'll push back or fold quickly. HOAs can be surprisingly stubborn when they think they have some kind of moral or legal upper hand." Then Charlotte asked about the orchard's current state. Was it fully operational, producing apples, or mostly idle? I admitted it was more of a hobby orchard now. I hadn't done a big harvest in a few years. "That might be part of how they rationalized it," she said. "They might think you're not using the land, so they can just waltz in and repurpose it. But the law doesn't work that way." She typed up a formal letter detailing the property lines, referencing the county records, and demanding Glendale Estates cease all activity. She also threatened legal action if they didn't comply within 10 days. I signed off on it, and Charlotte offered to deliver it in person to the HOA's main office. I loved that plan. Seeing her stroll in with a stack of evidence and a bold notice sounded like exactly the energy we needed. As we parted ways, I felt a surge of confidence. Glendale Estates might have money and influence, but we had the law on our side. I decided to drive back to the orchard for one more look, maybe catch Diane or someone else in charge. But when I arrived, the only person there was another security guard, who repeated the same rehearsed lines about it being private HOA property. I told him to give Diane a message. "Expect a legal notice soon." He just shrugged and jotted something down on a clipboard. On my way out, I saw a Glendale Estates SUV rolling through the new park roads. The driver slowed, gave me a cold once-over, then sped away. The tension was palpable. 2 days later, Charlotte called with news. She dropped off the cease and desist letter at the HOA's office. According to her, the receptionist nearly choked, and Diane looked furious when she realized what was happening. They refused to comment, but rumor had it they were planning to fight back. The next morning, Charlotte forwarded me an email from Glendale Estates legal counsel dismissing our letter as meritless. My blood ran hot, but Charlotte told me this was typical. "They'll try to scare you," she said, "or brush it off. Our next move is to file a formal lawsuit." We wasted no time. The complaint listed trespassing, unauthorized land use, property damage since they'd cleared brush and changed the landscape, and demanded immediate removal of all park installations. Charlotte also requested punitive damages, though we both admitted it might be a stretch. It signaled how serious we were. Then we sought a temporary injunction to stop Glendale Estates from hosting any upcoming events at the orchard. They had a grand opening picnic scheduled for that weekend. The idea of them hosting a big party on my land, complete with barbecue and kids running around, made me seethe. A few days later, the judge scheduled an initial hearing to consider the injunction. It took place in the county courthouse, a modest building with squeaky floors and cramped hallways. I arrived early, nerves dancing in my stomach. Glendale Estates was represented by a pair of attorneys in dark suits, looking as though they'd stepped off a corporate set. Diane was there too, wearing an expensive business outfit. She cast me a disdainful glance, but didn't speak. When the judge called us forward, Charlotte laid out the facts. The orchard was unquestionably mine. Glendale Estates had built a private park without any legal right or permission, and they needed to cease all activities immediately. One of Glendale's attorneys countered that the HOA believed the orchard was abandoned, effectively public domain. He even tried to argue that the farm was part of an old boundary agreement from decades ago, completely false. As the official records showed, Charlotte pounced on every false claim, referencing the county's digital records and Grandpa's meticulously documented surveys. The judge took it all in, frowning now and then. Finally, after about an hour of back and forth, the judge granted our request for a temporary injunction. Glendale Estates was ordered to pause any events, construction or landscaping in the orchard until the case was resolved. I exhaled in relief as the judge banged his gavel. Diane's face twitched with anger as she stomped out of the courtroom, followed by her attorneys. I half expected her to confront me, but she just rushed away. As Charlotte and I left the courthouse, a few local reporters tried to grab quotes. This dispute had apparently become hot local news. Private park on farmland without permission. Charlotte gave a measured statement about property rights and how we intended to see justice done. I made a brief comment about how I just wanted my grandpa's land respected. Then we slipped away before the cameras could pry further. Returning to the orchard, I found the security guard absent and the gate wide open. No more Glendale Estates pamphlets. That felt like a small win. I walked around, surveying the damage. They had anchored heavy wooden posts for that pavilion near the pond, hammered in park benches, installed some fancy lighting along the trail. In some spots, they'd cut down small trees to make way for the scenic viewpoints. My orchard was riddled with footprints and tire tracks. Rusty ran around, sniffing everything in confusion. It hurt to see the land treated like a casual weekend getaway for total strangers. That night, while rummaging through Grandpa's old files for more evidence, I found something I'd forgotten about. An old letter from Glendale Estates. Dated years earlier, it offered to buy a portion of the orchard to expand their recreational facilities. Grandpa had scribbled "not for sale" in giant letters across it. So Glendale Estates had tried the legal route once, been rejected, and apparently decided to do it themselves once Grandpa was gone. The arrogance of it all burned me up. This letter would be yet more proof they knew exactly who owned the orchard. Their claim of it being abandoned or questionable was just smoke and mirrors. Charlotte was thrilled to add the letter to our case. It shows they had prior knowledge and that they're not acting in good faith now, she said. Meanwhile, Glendale Estates scrambled to salvage their image. They sent out press releases claiming they'd enhance the orchard for the benefit of the broader community, but that was contradicted by their Glendale residents-only signage and locked gates. A local environmental group even weighed in, noting Glendale Estates had disturbed habitats near the pond, risking harm to local wildlife. The group reached out to me, offering to document any damage. I agreed, hoping to pile on more accountability. Despite the temporary injunction, Glendale Estates didn't remove their existing structures. They basically just stopped new construction and canceled their grand opening event. That alone was a partial victory, but it annoyed me that the pavilion, the benches, and the signage were all still there. I wanted them gone. Charlotte said that might require a final court order or a mutual agreement. Assuming Glendale Estates would back down at some point, they might decide it's cheaper to tear it all out than keep fighting, she speculated, but I wasn't holding my breath. A couple of weeks passed. The tension in town lingered. Some Glendale residents reportedly felt embarrassed by the HOA's actions. Others supported Diane, claiming the orchard was worthless farmland that Glendale improved. I overheard arguments at the local diner. People were forming opinions left and right, as if my orchard was the biggest scandal to hit the region in years. The hearing for the main lawsuit loomed a few weeks away, and in the meantime, Glendale Estates tried various intimidation tactics. A few times my water line at the orchard mysteriously got shut off, or the path to the farmhouse was blocked by random debris. But none of that deterred me. I'd stay there overnight if I had to. I was determined not to let them run me off my own land. In the lead-up to the trial, Charlotte and I compiled a mountain of evidence. We had aerial photos from a local pilot friend who flew his crop duster overhead, showing the orchard before and after Glendale's improvements. We had statements from neighbors who witnessed Glendale's crews hauling in materials. We had Grandpa's letter from Glendale Estates, proving they'd been denied the right to build. And of course we had the official county deed and boundary surveys. The legal argument was straightforward. Glendale Estates had no right, no easement, no permission, and no ownership claim. Their park was a blatant trespass. The only wild card was how Glendale might spin their story, or whether they had some hidden legal trick up their sleeve. The day of the trial arrived like a storm cloud on the horizon, tense and inevitable. The courtroom was packed with locals, Glendale residents, reporters, and even some folks who just found the drama fascinating. Diane sat at her attorney's table, her posture rigid, her face a mask of defiance. Charlotte and I sat at the plaintiff's table, with me trying to stay calm despite a pounding heart. My phone buzzed with supportive texts from Haley and other friends who couldn't be there. Opening statement started with Charlotte. She painted a clear picture. I was the lawful owner. Glendale Estates had built a private park without consent or compensation, disregarding property rights. Then Glendale's lead attorney stood, claiming that the orchard was abandoned and that Glendale was acting in the public interest by creating a recreational area. He also alluded to some old easement records from decades ago but provided no specifics. Charlotte rolled her eyes, clearly unimpressed. Next came witness testimonies. I took the stand and described the orchard's history, how Grandpa had carefully maintained it, how I inherited it, and how Glendale Estates never bought an inch of it. I mentioned the letter Grandpa received years ago and how he refused to sell. The Glendale attorney cross-examined, trying to imply I'd neglected the farm. "You live in the city, correct? You rarely visit?" he asked. I admitted it was true, but reminded him that absentee ownership doesn't negate my rights. Then Charlotte introduced the environmental group's findings, showing Glendale's construction had destroyed native plants and possibly harmed pond life. Diane squirmed in her seat. Diane herself took the stand eventually, exuding a controlled sort of fury. She claimed Glendale Estates had improved a neglected area, believing it fell under some vague common land concept. Charlotte politely dismantled that argument, referencing the official deed. Diane tried to pivot, saying Glendale acted in good faith, that they had no intention of stealing land. But Charlotte then produced Grandpa's letter, complete with Diane's signature at the bottom acknowledging his refusal to sell. The tension in the room skyrocketed. Diane tried to claim she'd forgotten that detail, but her flustered demeanor told everyone otherwise. By midday, Glendale's defense was unraveling. Their last big card was to argue that any forced removal of the park structures would be unfair to Glendale's residents, who'd already enjoyed the orchard. Charlotte retorted that fairness had nothing to do with it. Glendale Estates had built illegally, and the orchard's rightful owner wanted the land returned to its original state. The judge took a recess to review the evidence. My stomach churned as I stepped outside for some air. Charlotte patted my shoulder. "We've got this," she said, though I detected a flicker of concern. "You never truly know how a judge will rule." An hour later, everyone reconvened. The judge read from a prepared statement systematically dismantling Glendale's arguments. He affirmed that the orchard was legally mine, Glendale Estates had no valid claim or easement, and their park was constructed in complete disregard of property rights. Then he delivered the kicker. Glendale Estates was ordered to dismantle their installations, pavilion, benches, signage, within 30 days. If they failed to comply, they'd face steep fines. He also granted me the right to pursue damages for trespassing and environmental harm. A hush fell over the courtroom, broken only by a few gasps. I clenched my fists in silent victory, wanting to cheer but holding back. Diane's face was a storm cloud. She conferred with her attorneys, who looked grim. Meanwhile, Charlotte and I exchanged relieved smiles. The crowd began murmuring as the judge left. It felt like a weight had lifted from my chest. Outside the courthouse, reporters swarmed. Charlotte gave a concise statement about the triumph of property rights and the importance of respecting legal ownership. I voiced relief that justice prevailed, though I also noted the sadness in seeing my orchard treated so disrespectfully. Then we drove back to the orchard where the Glendale signage still stood, ironically proclaiming Glendale Preserve, no trespassing. Within a week, Glendale Estates tried to negotiate a settlement to pay fewer damages if they removed the pavilion themselves. Charlotte hammered out a deal that covered the orchard's restoration, including replanting some of the shrubbery they'd torn out. I insisted on extra clauses requiring Glendale Estates to fix the pond's shoreline, which they'd messed up with their gravel paths. Diane seemed resigned, her bravado drained. The sight of Glendale's workers dismantling the pavilion, hauling away benches, and erasing the nature trail signs was oddly cathartic. It wasn't the orchard Grandpa left me, not exactly. It was battered and changed. But at least it was mine again, free from the brazen takeover. During the removal process, I walked the property daily, marveling at how quickly Glendale had built their so-called park. Now they were ripping it all out just as fast, hoping to avoid more fines. A few Glendale residents wandered by looking sheepish or apologetic. Some muttered that Diane had misled them about the orchard's status, claiming it was under negotiation. A couple even apologized directly to me. I appreciated their words, though it didn't erase the damage done. At least I wouldn't have to see strangers hosting barbecues or family gatherings on my land anymore. By the time Glendale fully pulled out, the orchard was littered with patches of raw earth, exposed roots, and a few stray scraps of building material. I hired a local landscaper to help restore it. We replanted native shrubs, replaced mulch around the apple trees, and cleaned up the pond's bank. It would take time for the orchard to regain its original tranquility, but each day it looked a little better. Rusty joyfully bounded around as if celebrating the orchard's return to normal. Meanwhile, Charlotte and I prepared a final push for compensation. Glendale Estates had caused extensive property damage and environmental disruption. The settlement negotiations dragged on for weeks, with Diane's team lowballing me. Charlotte stood firm, and we eventually reached an agreement that covered the restoration costs plus a bit extra. I didn't walk away rich, but I felt satisfied that Glendale was held accountable. Rumor had it Diane's position at the HOA was on shaky ground. Some residents blamed her for the fiasco, and apparently an internal revolt was brewing. I didn't relish her downfall, but I couldn't deny that she'd brought it upon herself by overreaching in such an arrogant, underhanded way. When the dust settled, I made a vow to spend more time at the orchard. Grandpa's place deserved better than being neglected or left idle. I'd reinvest the settlement money in making it a small but vibrant orchard once again. Maybe open it up for local kids to learn about apple picking or nature walks. On my terms, not under some random HOA's banner. Haley volunteered to help, and Charlotte said she'd love to visit from time to time. We started brainstorming ways to incorporate a community aspect, perhaps a monthly farmers market or a harvest festival for everyone, not just an exclusive group of residents from a gated community. One crisp afternoon, I was clearing brush when I stumbled upon an old plaque, half buried under leaves near the pond. It bore my grandpa's name, carved into the wood with the inscription, "Our land is our memory, treat it well." He must have set it there as a private reminder, or maybe planned to attach it to a bench that never got built. Holding that plaque, I felt a rush of emotion. He'd always believed in protecting the land, preserving it for future generations. Glendale Estates' intrusion, although infuriating, had also awakened me to the farm's value, far beyond its market price. It was a repository of family history, a quiet place that deserved respect. And so, in the end, Glendale Estates built their private park on my farm, but my lawyer dropped a legal bombshell that blew their grand plans apart. They lost everything they'd poured into creating that unauthorized retreat, and they were forced to pay for the cleanup and restoration. I stayed steadfast, guided by Grandpa's passion for the orchard and the law on my side. The orchard survived, battered but unbroken, ready for a new chapter of growth and genuine community spirit. I learned that no matter how powerful or connected a bully might be, standing your ground with solid evidence and good allies can topple even the most brazen attempts at theft. That orchard stands as living proof of the difference between an entitled appropriation and a rightful inheritance. At the end of this tumultuous journey, I carry one clear lesson. We don't just inherit land in a legal sense. We inherit responsibility. Whether it's a farm, a family home, or a piece of history, it's our duty to protect what's entrusted to us. When someone tries to seize what isn't theirs, whether through intimidation, backdoor deals, or outright fraud, standing up for what's right can preserve more than physical property. It preserves the values and memories tied to that place. And in the long run, no flashy sign or corporate tactic can replace the deep roots of genuine ownership and care.